Good evening, everybody. And we're saying that we need to select you in the room, when you know who you are. And then we have an awful lot of people who are joining us online from all over the country, in fact, quite a few internationally. So we have people who are going to be viewing this from India, from the Philippines, from Hong Kong, and welcome here. This is the first of 3 lectures that we're going to be doing, and the 3 lectures are about construction contract administration. And I'm going to do an introduction in a minute, but my name is Mark Thomas, and I'm the organiser of these 3 events. And I'm going to introduce my co-lecturer in a couple of minutes. So what I'm going to start by telling you is just a bit about the CIR. And although our organisation is called the Institute of Arbitrators, most of the members are not arbitrators. We're expert witnesses, we're adjudicators, we're mediators, but it's all about dispute resolution. So the people who are involved with the Institute of Arbitrators are involved with dispute resolution in many, many different forms. And our branch is the Thames Valley branch, which roughly, oh, hang on a second, it's not working on the screen again. Okay. Yeah, well, got it. No, it's not changing. Just bear with us online because slides aren't moving in the room. So just clear off. I don't clear off. Yeah, there's that. Right, there we are. So people in the room, you can now see a pretty picture of 3 counties, and that's roughly where we are. We'll say 6 to 10 meetings a year. In fact, this year we're doing 14, and we will have about 3 events that are going to be charging events, and then those 3 events will pay for all of the others to be free. So the vast majority of our events are free CPD, and we move them around. So we go to Milton Keynes, we go to Maidenhead, we go to Oxford, Reading, and then we're coming here for the first time to Chorleywood. So we've not been here before, and this is a bit of an experiment. So let me tell you a little bit about the events that we're going to be having coming up. Well, this is the first 3 that we're doing. As you can see on the screen, tonight is the practical completion one, which I'll introduce in more detail in a second. But then in 2 weeks' time, we're doing extensions of time and delays, and that will again be Seth. And then in 4 weeks' time, I'm going to be talking to you about payment certificates, payment and pay less notices. We'll be doing that in 4 weeks' time. And then we have some other events that are booked already for the autumn. So we've only got 3 up there, there will be more. But the first one is on neighbourly disputes. So that's boundary disputes and sort of anything to do with nuisance, which is a bit of a one-off topic. We have a complete expert witness day that we're organising in October. So that will be a lot of very good speakers, and Anthony will be at that. That one's a paid event. That's one of the paid events. And then the last one we've got planned at the moment is in adjudication and construction industry, and that will be Jennifer Guthrie, who will be speaking about tracking down and running claims where you've got an insolvent contractor. So just to come on to this evening, practical completion and snagging. Our speaker this evening is Seth Handley, and Seth has said to me, would I please introduce him just basically as a jobbing architect. So Seth is practical and a practicing architect. I'm going to leave you to decide in your own views, by the end of the talk, whether or not he knows more than an ordinary architect. And I'm going to embarrass him in one respect, because I said I wouldn't embarrass you. Just look at the qualifications. Right. Anyway, so we are now going to pop over to Seth's presentation. I'll change the slides, and then Eddie, if you can do the same thing from your side. Yep. 1 second. Yep. No. Yeah. There we are.
Excellent.
Seth, it's all yours.
Thank you very much. Good. So just stop that.
Oh, sorry. Two things to say while Seth is just putting his stop watch on. We're going to take questions at the end. So anybody online, would you please send your questions into the chat box on the last one at the end? And was there anything else that you wanted to say? No, I think that's it. So,
Good. Okay.
over to you.
So practical completion, including snagging. I'm going to start off with the basics, and then I'm going to go into more complicated areas. And move on to the next slide. You're probably thinking, how is practical completion defined? How is it recognized? And how can it be applied? So I'm going to go through the very basic areas of practical completion to begin with, and then into the more advanced areas dealing with sectional completion, etc. So the advanced considerations I'll be looking at, there's one case where a contract administrator was actually accused of colluding with a project manager. There's another case where the parties expressly specify practical completion can be certified without a contract administrator. And also, I'm looking at the question, can practical completion be certified if there's an outstanding so that's in the second section. I was asked to look at snagging before I go into practical completion, and I've got three definitions. The first one is mine. The second one is Nexus, and the third one is Dr. David Chappell, who wrote this blue book that I have with me. So my own definition of snagging is you're working on a project, it's coming to the end, and the builder comes up to you and says, I want my practical completion certificate. You then go around the site very critically, and you have a notepad and you note everything that's not quite finished or not quite built properly, and you make a list of all of these things towards the end of the project, and that is a snagging list, the things that have to be completed before practical completion. Now, let's practical completion and snagging. It's his view that it's actually a bad thing, and he submits that it's a bad thing to do because the contractor should know what they're doing. And if you're putting on a piece of paper what they need to do to finish, very often this leads to disputes. So what we can do is we can look at a number of examples that I've got in the next slide. So these are cases where snagging has been considered. And snagging is not mentioned in any JCT contract. But term with by the judge going through that below and above the cavity tray, things that you know about, and these were all looked at. So this is a very interesting case, 154 pages long, and it just shows that the courts will look at snagging, and it is an acceptance to do snagging lists. Now, in this particular case, the contract administrator was different from the architect, and the client was taking action against the builder, the contract administrator, services engineers, and the architect. And the contract and the client settled out of court, it will say specify practical to actually specified it when they achieved unlimited damages, but they settled for £80,000 out of court. So that's the first case. And Vancouver Bank, as you can see, the date 2024, I think it was decided about 4 weeks ago. So it's the latest case. Now, the other case I'm going to look at is Moorlands and Conwell. You can see there, the reason I picked that is because it's a Court of Appeal case, which will state the law. And in that case, the client entered an agreement with the builder directly. It's because the builder and the client fell out concerning the quality of work that was involved. And the client and the had action in the county, the builder was looking for more money, and the reporter in Southampton said, well, Mr. and Mrs. Conwell, very good you're bringing this case before me with your snagging list. They said, but you haven't given it to the builder. And the builder's here, and he wants to do the work. And you're looking for damages for finishing the job, and he's here ready, willing, and able to do it. And you want me to award damages based on your snagging list. Now, the Commonwealth weren't at all happy, and in fact, the builder wasn't happy either. But that's another matter. So it was referred to the Court of Appeal, and the Court of Appeal said that the court had got it absolutely spot on, that there's no point the client or the architect or the surveyor having a snagging list if they don't give it to the builder and say, this is what we need to do. So I do disagree with Dr. David Chappell that it may lead to a few disputes, but if you don't specifically tell them what they have to do, then of course it's going to be very difficult. Now, the recorder used the expression, the Conwells were living in the house every day, and they experienced everything that annoyed them, and they wrote it all down. From that point of view, it just shows snagging is a good idea, but you've got to obviously give it to the builder, which is contrary to the submission of Dr. David Chappell. So in my view, snagging is a very good idea. When you get to the end so far, there may actually be a few more things I need to add to it as we carry on the project. So that's consideration of snagging. I'm now going to move on to practical completion. So this could be you working in your office, busy designing, busy sorting out other things. And this is a very small thing in your overall script as a guide to use concerning practical completion. And you're probably thinking, is it now? Are we almost there? What are the requirements? And what is the consequences if I specify practical completion now? What happens? So I'm going to go through the basics now, in particular with the JCT minor works. And I'm going to look at the guidance or the recommendations of JCT with regards to filling in the forms. And then we can look at some other more complicated cases. So the clause that deals with practical completion is 2.10, and it's on the screen. And I've got the 2024 edition here, and it doesn't change. So I prepared these slides based on the 2016 edition, which we're using. So when it comes to the 2024 edition, it's exactly the same words. And what the clause says at 2.10 is that the contract administrator so by the date. Now this is very important. The dates when, in his opinion, the works have reached practical completion. And also that's, and the contractor has complied with 213 and 3.9 in respect of documents and information. So that's the clause that deals with practical completion. And what I'm going to do is, in order to work out what it means, I'm going to look at the clauses around it, because it'll help show what it doesn't mean, and then we get a better idea of what it does mean. So if I go on to the next slide, we've got clause 211, and this is defects. So after practical completion, it says if any defects, shrinkage, or other faults in the work appear. Now, appear is the word to look at. If any of these faults appear within the rectification period due to materials with a workmanship in accordance with the contract, then of course the contract administrator will have to make a list at the end of the defects liability period, which I think the default is 3 months in the JCT, and it could be longer. But the key to that is, after practical completion, the contract administrator can only ask for defects that appear after practical completion to be corrected. So there's no scope for the contract administrator saying, oh, well, just let them deal with that after PC. They can finish that off, and they finish that off. There's no scope for the contract administrator having that authority. The only thing they can instruct is latent defects. That are things that are not patent at the time when the contract, the practical completion certificate is actually certified. So this is where we get the conversation and the discussion of patent and latent. So before practical completion, everything that's patent, everything you can see on the project that's either defective or not quite finished, that needs to be finished or corrected before practical completion. And latent, of course, means you can't see it, so you can't ask for it to be corrected before PC. So everything after practical completion that you ask to be corrected will be a latent defect. So before practical completion, all the patent defects and work not done must be finished, because after you can only ask for the latent defects that are materialized to be corrected. So I'm moving on to the next clause, which is clause 212, and that's entitled Making Good Latent Defects. So when in the opinion of the contract administrator, the latent defects have been corrected, then the contract administrator shall issue a certificate, which confirms that after practical completion, the administrator's only got powers to ask the builder to fix latent defects. If there's anything still surviving from before practical completion, there's no authority to ask for that to be corrected. So we know when practical completion is, because all the patents have been corrected. Because after practical completion, you can only instruct latent defects to be corrected. So I've got my own question you should ask yourself, and I think this is the true situation. So if you're at the point when you're thinking, I think I'll give them practical completion certificate today, you need to ask yourself, if there's anything at all that still remains to be done, would I be happy paying for that to be done out of my own pocket after practical completion? Because in effect, that's what you're doing. You're putting yourself at risk of having to pay for the work to be completed if you don't have anything to remain uncompleted, practical completion. And the answer has to be no, it's got to be totally complete. So now I'm going to move on to the JCT's guidance for practical completion, and this is also by Dr. David Chaplin. And I'm going through the guidance and notes on the basics of filling in the forms and practical completion that David Chaplin, as editor, has provided to JCT users. So they've reworded clause 210, and they've said, when in the opinion of the contract administrator, practical completion of the work is achieved, this must be certified. And they've used the word must. Now, this is different from the JCT, because the JCT says the date that practical completion is achieved must be certified. It's the date that's important, because you're very, very busy. You could be doing the inspection on a Monday. You could be doing something else on a Tuesday, off on a Wednesday. You're back to the office on Thursday. But the most important thing is that the date of practical completion is certified, which of course is the Monday. So the guidance notes say that the clause in the JCT has the proviso that the information that needs to be provided in accordance with 213 and 3.9, that information must be provided before we certify the completion. So we're going to look at 213 and 3.9. 213, and that's because I've got the contractor design version of the JCT, is all of the design information they're going to provide concerning the contractor design elements. And 3.9, on the next slide, is all of the things that the contractor needs to provide with regards to health and safety. So it's assumed that they are the principal contractor and they will have the health and safety file, which they'll need to hand over to the owner with regards to names and other items. So these two things must be fully satisfied with regards to providing information before the practical completion certificate can be certified. And that slide pretty well says what I just said. Now, filling in the form, the guidance note is very, very specific, and it doesn't really give any leeway for ambiguity. So the guidance notes are saying, go back to the JCT, open the pages, look at the first page, look at the name and the address of the employer and put them in this stuff. Make sure the signature is the signature of the contract administrator listed in the JCT contract. And also whatever's written in the JCT with regards to location of work, the abbreviation of work, and most importantly, the contract date. And this is all very, very important because obviously afterwards, let's say it's a year later, and you're looking back and thinking, where's that certificate for? Which project was it? And also a certificate number should be entered. With regards to the circulation, the guidance note suggests that you send the original to the employer and you send a duplicate to the contractor, and at the same time send copies to the surveyor, and you put a copy in the file. Now, of course, we all live in the modern world with iPhones and other forms of communication. And if it's the 2016 JCT, the provision of notices is that you send it to the address in the contract. And the address in the contract will be an address. So you can, of course, send the certificate as a PDF attached to an email, but the official version of the certificate will need to be posted. And if you put sign for post, that's obviously better. Now, of course, I've got the 2024 edition, and this is different because it states notices can be served by email. And the email address to use for sending notices is here in the latest edition of the 2024 JCT. But with the 2016, I think we still need to print it off and post it with Snagging for the standard. Now, some guidance notes concerning if you still keep a hard copy in a file. Just write on it when the end of the rectification period is, because it may be in 3 months' time you're thinking that project that we finished 3 months ago. Do I need to look at defects now, or was it 6 months? So the guidance note suggests that a note is made when the rectification period has reached the end, and you can quickly open the file and you can see, oh yes, it's the 6th of September, this completion was tomorrow. And then you don't have to go back through the file and look at what was agreed, etc. So the next slide pretty well says what I've been saying about putting in the rectification period. So we'll move on. I'm not sure if Eddie, you can zoom into this.
On my screen, yeah. So, I think the viewers.
Okay.
The viewers.
So this is the guidance notes, typical practical completion certificate with nothing filled in. And that's the standard JCT blank form you can get with your Crystal, whether it's an ICS or this JCT standard. So a little black box, it says SBC, IC, ICD, and W. So that means standard building contract, intermediate contract design, or minor works. So this is the form before anything's been put on it. And the next slide is their recommendations. And I've got arrows pointing to things to look out for. So what is very good about the example is they've obviously got the person mentioned in the contract who is signing it, Dip.Arch Associates, and his name, Dip.Arch, in the signature box. They've got the acquiring address, the contracting address, they've got the works. Now we're getting on to things I've got a few comments on. And the main thing is, in this particular example, they've got the 21st of December when it's issued, and the 21st of December when practical completion is achieved. And it's very likely that when you issue the certificate, it will be a day or two after you've done the inspection. But what is vitally important, that the day that you agreed that it was complete, that's the date in the box. And we'll go in the following slides to actually see why that is so important. Now, I've also got arrows pointing to all the little boxes at the bottom. They should really be ticked if it's going to the employer or the contractor in the file. They should really have a tick in there to show who it's going to. Now, the consequences of certifying practical completion is the next slide, which I'm going to go through. And I've actually included one or two more, and a lot of people who have written about this, but I'll say why I've included them. So I've got 6 reasons of consequences after practical completion. And probably the most important reason the builder wants to get the certificate is because, well, I don't know how many projects you've worked on, but I've never ever worked on a project that's finished on time. So the builder is going to be absolutely petrified about liquidated damages building up daily or weekly. So the vital reason they want a certificate is because it stops the accumulation of liquidated damages. Now it's up to the client as to whether they give notice to deduct them. But obviously, when the practical completion certificate is issued, the number one thing is it stops this money accumulating, whether it's daily or weekly. And even on small programs, it could be as much as £100 a week, £700. Sorry, £100 a day, £700 a week, and after a month, you know, that's £3,000 or whatever it is. Now, the second reason the contractor wants practical completion is because, of course, under the JCT, the retention is 5%. That's reduced to 2.5% of practical completion. So just with a certificate, he gets 2.5% of the contract value, or he gets 97.5% of the contract sum. But of course, the 2.5% is what he gets without actually having done any work. So he's very keen to have the certificate to get the extra 2.5% release from the retention. And one thing that contract administrators shouldn't forget is that when practical completion is certified, they need to inform the employer because they need to make sure they have insurance for the works. Because obviously the main contractor is going to stop their insurance once they have practical completion because the employer will be taking over. So there may need to be some notice given to the employer to avoid having a few days where there may be no insurance at all for the project. Now, as we've gone through already, and I've got as number 4, after practical completion, the contractor can only be asked to correct latent defects, that are defects that only appear after the certificate is issued. And number 5, after practical completion, the mechanisms contained within the contract, like clock, cogs in a wheel or cogs in a watch, they all link into each other and the whole watch is turning the hand. We've now got the rectification period in the final certificate. It's all being programmed. So we've got the 3-month rectification or defect liability period. And at the end of that, once they're corrected, you've got the final certificate. So all the cogs are in motion to have the contract being brought to its conclusion after the practical completion certificate has been signed. Now 6 is one that isn't in many textbooks, but I've added. And we'll see in some slides towards the end the reason why. And that is, looking on the long term, practical completion from the point of view of the builder is the date of accrual. And what that means is the builder is potentially liable to the client for a certain period under the Limitation Act. And the start of that clock ticking is practical completion. And we'll be looking at a case that was decided very recently concerning a project where the claim was made just days after the time of running out and it had to be thrown out because it was too late. So that's the consequences of serving a practical completion certificate. So that's the basics. We're now going to look at some case law, and towards the end of the case law, they get very complicated. And but the initial cases are fairly standard, and they agree with everything we've been talking about so far. So obviously, the most important, the highest court we have, used to be called the House of Lords, now the Supreme Court. So the first 2 cases from the House of Lords, and I've got each of the cases by the person who's actually written the judgment. Of course, the House of Lords is probably 5, and Viscount Dip.Law wrote the judgment in Jarvis and Westminster. So quite a long time ago, 1970. But this was a case that considered practical completion, and everybody's been following it since then. Now, having said that, it was an over to dictum comment, which means it was comments made while they were reaching a decision on the dispute before them, but it's still very, very important. So the definition here is practical completion. It means the completion of all the construction work that has to be done. And as we've been talking about, this is supported by the fact the defects liability period runs from the date of practical completion. So the second case in the House of Lords, the decision was given by Lord Dip.Law, and that's Kay and Hosea Dickinson, which again is quite a long time ago in 1972. And in that case, Lord Dip.Law said the construction period continues until the builder has completed the works to the satisfaction of the architect. So as far as the absence of any patent defects and materials or workmanship are concerned, and it ends with the issue of the certificate of practical completion, and then the defects liability period starts. So they both agree with each other. Everything has to be correct, no defects, the work's finished, and the practical completion certificate, and afterwards it's just dealing with latent defects. And that's the basic principle of practical completion. But of course, we're going to get through a few more complicated cases. And the first one of which was the Court of Appeal, decided very recently, 2019, Mears and Cost Plan Services. And this is all to do with student accommodation, but probably a lot of you work. And the agreement was that none of the rooms for students would be any more than 3% smaller than schedule. So the whole building was built, and it came to writing the certificate of practical completion. And the company that was going to be renting the student accommodation was submitting you can't write a certificate of practical completion because 56 rooms are actually smaller than the 3% that was agreed in the contract. So the contract expressly says none of the rooms shall be smaller than 3% of the sizes specified. 56 of them were. So the decision was whether or not the contract administrator could prepare and sign a practical completion certificate. And it's quite a dilemma because the building's totally finished. And the people who are going to be letting it are saying, well, we don't accept it. It's 56 of the rooms are smaller than 3% of the agreed tolerance. We think this gives us an excuse to get out of renting it because this goes to the root of the contract. So it repudiates we breach. Therefore, we're relieved of any future performance in renting, taking on student accommodation. So that was the case that was put to the Court of Appeal. And the Court of Appeal looked at an equally interesting case, Ruxley and Forsyth. I can't remember what the year was. But this gentleman was having a swimming pool, diving pool built in its own building in his garden, and it was finished. And this went to the House of Lords, and unfortunately, the diving pool was, I think it was 6 inches too shallow. So the client said, well, actually, I want to knock the building down, and I want to take up the swimming pool, and I want to start again, to have it the right depth. And the court looked at that and thought, well, you can actually still use the dock. It doesn't make it any less usable. It's a very small inconvenience. And the court followed Ruxley and Forsyth in this case of Mears, and they said, yes, some of the rooms are out of tolerance, but you've still got the building with the student rooms. And it's not a breach of contract that goes to the root of the contract depriving you of the student accommodation. So the Court of Appeal said, yes, you can write the practical completion certificate. And that was the answer to that difficult case before the Lord Justice Bruce. Now, this case is going back quite a long time as well. And this is the case that all senior contract administrators, a number of whom are with us today, this is the law that they remember. And this is never William Press. And this was decided by Judge Newell. And the expression that they use is that in certifying practical completion, the work must be finished with all bar de minimis work. It's that Latin phrase that contract administrators like to refer to. And this has been memorized by a lot of contract administrators. Of course, it's correct, but what does it mean? Now, the phrase means that the law is not concerned with things that are so trifling and so smooth. So if you just think to yourself, this project's come to an end, would the law be worried about this, or is it so smooth that really it comes in under the de minimis heading? And that could be a way that you decide whether or not to issue a practical completion certificate. So this is a very well-known case that's cited by most senior contract administrators from 1980. And the next case is complicated, and it concerns a mixed-use development. So above ground floor, there was, I can't remember whether it was flat, so it was this ground floor was retail. And planning conditions required level access, as it would do for the public as a retail units. So the contract administrator, as far as I remember, certified practical completion. And the case was raised by Mendeley Investments and Seripsara. And it went before Judge Parfitt. The question was, can they issue a certificate of practical completion when a planning condition hasn't been complied with? And if you read the text there, you'll see that the experts for both sides said, yes, of course they can. Yes, otherwise we could never get things built. you can never have a certificate. But as you'll see, the judge decided, no, you can't. And the practical completion certificate was invalid. So that was a very interesting case. And I would say that any requirement of building control or planning, if it's not complied with, then it's probably unlikely you can actually issue a certificate of practical completion. Now, I've put this case in because I think every project I've worked on has kind of felt like this, and it's Celtic Board and Van der Heijden in 2010. And if I give you the scenario, you ought to think of so many projects. So the builder reached a point in the project, and he went to the contract administrator and he said, I've reached practical completion. I want the certificate. I'm not doing any more work. I'm leaving site until I get the certificate. And that's exactly what he did. And the contract administrator said, I've got this snagging. So there's still some important things to do. And the builder said, no, I'm not doing anything more until I get my certificate. Now, Mr. Justice Colson, as he then was, looked back at Jarvis and some of the list, and he quoted, practical completion is the completion of all the work that has to be done. And it can't be issued if there are patent defects. And so as a result of this, Mr. Van der Heijden, whose company was named, he had to pay for the employer, getting another builder to finish the work, and for liquidated damages until the work was finished by the other builder, £700 a week. And I think he had to pay for the contract administrator's additional fees. So that was a very, very expensive start for the builder to take on that particular program. So if they're bossing you around, it's good to remember this case, Selby Board and Van der Heijden, as to what the results will probably be. So this is another very well-known case, and when we have Mr. Justice Aiken, things start to get a bit complicated. So this case is quite old, 2012, Lillian McKay. But the definition of practical completion is very good. It's very specific. And in further cases, we will see how this unfolds. So if I use the exact words of Justice Aiken, he says, where there is a disagreement as to practical completion and what it means, well, it means completion for all practical purposes, and what that completion entails must depend on the nature, the scope, and contractual definitions of the works, as they may have developed by way of variations and architects' instructions. I think that's a brilliant definition, because projects, they start off with a set of drawings. We all know what's happening, but by the time you finish, it's gone down lots of routes and there's been lots of instructions. And in this particular case, the client, as you can see there from the notes, the client said, I don't want this part of the works to be built in. So then what happens with regards to practical completion? Well, of course, the same date exists. Practical completion can be certified, but there's no need to wait for the work that the client has removed from the scope of the building. So the next case of Mr. Justice Aiken is equally complicated, but it refers back to the basics we went through at the very beginning. That is, before practical completion, patent defects, patent work that remains to be done has to be completed. After practical completion, only latent defects can be retracted. So in this particular case, very much like the former case, unfortunately, the contract administrator certified practical completion, and there was quite a lot of work remaining. Mr. Justice Aiken had said, well, you shouldn't have done that. You shouldn't have certified work remaining. You can't get damages for that. The only damages you can get after the certificate of practical completion is the damages that represent the cost of rectifying latent defects. So this just shows the consequences of certifying too. It can lead to a lot of problems for the client. Now the text is very small because this is very complicated. It's very complicated because there is no contract administrator certifying practical completion. This is a commercial agreement between a subcontractor and a main contractor, and it's a JCT design and build subcontractor. And I'm just going to say that the express terms recorded, and that is when the subcontractor feels he's reached practical completion. It's a bit like evaluation. The subcontractor serves a notice on the main contractor saying, I've reached practical completion. And if the main contractor doesn't counter that, saying, no, you haven't, you've got to do this and this, then they have practical completion under that contract. Now, the reason I'm saying, and this will only apply to commercial contracts, is because unfortunately the contractor went bankrupt and they were trying to recoup or gather in money. And the building was flooded by the sprinkler system. And the question was this before or after practical completion? Was this before or after practical completion of the subcontract, the main project? And the court had a look and they said, well, SFS Fire Services Limited, they'd served the notice saying they were complete. That wasn't counted. So they were complete, practically complete, and therefore it doesn't come out of the builder's insurance. It comes out of the other insurance that they were claiming for. It probably would have been subcontractors' insurance. So it meant that the main contractor could actually claim and get the colossal amount of money for replacing the hardwood floor, £600,000. That was the cost of the leak. Now, the other thing, of course, I said this was quite complicated, is of course you've got practical completion of the subcontract. This is all practical completion of the subcontract, but it wasn't practical completion of the main contract. So it gets even more complicated from that point of view, because it had its own criteria for achieving practical completion. That is the service of the notice and not getting notice for 14 days. Now I put a note at the bottom saying this sort of thing, I don't think it could be used with this. It could only be with a commercial, between two commercial parties, contractor and subcontractor, and contractor with construction company. It's too complicated. Now, I mentioned at the very beginning consequences of practical completion, and I said I've put down accrual. That is the start of counting the time by which the contractor remains liable, 6 years or 12 years, whether it's a contract under hand or executed as a deed. And Mrs. Justice O'Farrell in 2018, 6 years ago, had a case of Swansea Stadium and the City of Swansea and the name of which would include the rest. It was City Council, something City Council. So the claim was brought because they felt that the main contractor who built the stadium hadn't built it correctly, and they were having to spend so much money to correct it. The contract was executed as a deed, and they said, yeah, but they didn't actually finish before practical completion, so we should really start it from when they finished. And Mrs. Justice Farrell said, no, time starts to run from practical completion, which is the other reason again, consequence for completion. So in that case, the claim was thrown out because it was just a very short period. Now, this is another very difficult, complicated case, and it concerns Warwick University, who I'm sure you all know, and Balfour Beatty, who you also know. Now, the people who drafted the contract had liquidated damages for different parts of the building. So the main equipment plan was £5,000 a week. It was a dynamometer room was £15,000 a week. cafe was £10,000 a week, and all the other works £65,000 a week. Now this dispute went to adjudication, and a very famous adjudicator for now you can university with some rooms open being used and others not being used. And the University of Warwick took it to the High Court, and Judge McKenna said this is perfectly workable. Any part of the building that the employer can use, can move in, use that space, then they achieve practical completion for that space. So it can all be done individually, space by space. So that's how practical completion works on a section completion basis. If the employer can move in and use a part of the building, then the liquidated damages for that cannot no longer apply.
Just nice. I'm back to that. Presumably, there was no section completion certificate, so it was being operated as partial completion.
Yes, I think that was it.
Yes, because it's very rare that we have section completion with lots of different buildings. But we might then decide, okay, this one's ready, so we'll take partial possession of that, which of course will have the effect of lifting the liquidated damages. But we then get rid of, I guess it was a patchwork approach, is that what happened?
Yes. So the next case, Mr. Recorder Singh, QC. This is an equally complicated case. And it's to do with loss and expense. I know there's a few people with loss and expense. So the contract said you cannot claim loss and expense after practical completion. So this is a project, I think it's Swiss Cottage, Ground Construction Limited, and Galfoot Try. The groundworks contractor made a claim before practical completion, and then 3 years after practical completion, they put in, I'm going to be careful with the words I use, they said they just elaborated or explained the claim better. They said it was put in before, 3 years later, they said it was another £231,000. So the adjudicator, a very famous adjudicator, said, I agree with you. And then it went before Mr. Recorder Singh. Now, what's very, very interesting is, as you know, adjudication decisions are enforced. And this was a matter, a dispute as to fact. Sorry, no dispute as to fact, I apologize, a dispute as to law. And therefore, the Part 8 claim could be considered by the judge on a very quick basis. And he said, well, no, I don't agree. I'm very sorry, but the extension of the claim that we say was made before practical completion, £239,000, was made after practical completion, and therefore the award was not valid, and Ground Construction Limited had to repay the £239,000. Now it's very, very, very rare that an adjudicator's decision is not enforced in the High Court. But in this particular case, because it was such an area that both sides agreed on the facts, they could actually give a ruling as to how the law applied to it. But it is very rare. Because there was no dispute as to the facts, the 3 years afterwards that the initial claim was extended. Now, this is the last case we're looking at, and I don't want you to get too worried. January 2023. Client may be one of the richest people in the UK, and he bought a number of houses in Hampstead. And some people just like to make things complicated. So with this particular house, he was only buying it if it achieved practical completion on a date they set before the works began, before he bought it. So of course, you know what's going to happen. The practical completion certificate was issued on the date, the last date. And the client didn't move in. He waited 8 months before he moved in. And he moved in. And then he said, I can't, it's still not finished. So he moved out and he lived somewhere else. So obviously he's very annoyed. And he says, I bought this house on the basis that PC was achieved on the 31st of October. I got a certificate. And the claim he made was collusion between the contract administrator and the project managers, unlawful collusion. Now, this is really quite an onerous thing to claim against the contract administrator. He fixed the books. So instead of saying you were negligent, he said you were colluded. It's fraudulent collusion. And don't worry, because the court said, well, this is really quite a serious thing to accuse someone. And on the basis of what you've submitted, there isn't enough information for them to reply, and they threw it out. So it has a good ending. So the claim was thrown out, it was struck out because there wasn't sufficient detail to prove that there was actual collusion. Now, in this particular case, the employer sued the builder, project manager companies, the individual project managers, the contract administrator, and the architect. They were all on the list, and I've just got the contract management. So the client was very, very upset, but it ended quite well in as much as it was good. Okay, so practitioner texts. Now these are texts that deal with construction law, and I'm just going to quickly go through Keating and Hudson, and my 55 minutes will be up. So Keating, which is a very good construction law practitioner text, defines practical completion as being when the works can be practically complete, notwithstanding that there are latent defects, and that a certificate of practical completion cannot be issued if there are patent defects. And the rectification period is provided in order to enable defects not apparent at PC to be remedied. Practical completion means the completion of all the construction work that has to be done. And then the final bullet, the contract administrator is given a little bit of discretion to certify practical completion where there are very minor items incomplete on the minimalist principles. So that's Keating. The other practitioner text is Hudson. And Hudson, on a similar basis, refers back to the decision of Viscount Dealhorn in the House of Law, saying practical completion suggests the completion of all construction. And Viscount Dealhorn also held, if there are patent defects, it should stop a certificate being issued. And also, Hudson refers to the case of Newey QC, which is the de minimis case. An architect would have a discretion where there are very minor de minimis works. But if there were patent defects, the architect could not give a certificate of practical completion. Now, on the JCT major works, which is something we have considered, it also states that practical completion only when the statutory requirements have been fully complied with. And that, of course, doesn't exist in the JCT works. And the final bullet of Hudson is the certificate of practical completion cannot be given for patent defects. So this is how complicated it can be. The blue is the builder, and the olive is the employer taking up occupation of the building, and they overlap, and it raises very, very difficult questions. So what happens if the employer's got partial possession? And this is what this mentioned. Also, what about if there's a variation in a period where the builder shouldn't actually be in a period of delay? And what if the employer gives an instruction to accept some deficient work? What happens then? Or what if the employer says that work that remains to be done, I want to remove it? So, in summary, the basics are all the work needs to be complete for practical completion to be certified. There cannot be any paper defects, but it's subject to the de minimis principle. And the reason is because you can only instruct legal defects are corrected after practical completion. So that's the basics summary, and the advanced summary is you can devise your own way expressly when you prefer practical completion to be achieved under the contract. You can stipulate when practical completion is achieved by contractual mechanisms. We considered a subcontractor giving notice that it reached PC, and if it wasn't counted, it was how was achieving. And the last point under the advanced summary is that, of course, the contract administrator should really have a look to make sure that none of the statutory or planning requirements are outstanding before they write a certificate of completion. So that's 55 minutes, 38 seconds. I was given 55 minutes, so I'm very pleased. I'm practically complete.
Yes. It should have been a confidence there. So I think what we'll do is, if you'd like to, I think we'll do two things. We've just discovered that Paresh can't see the chat box, so you're going to have to
Read the
put it
questions.
up on the chat box because it's only on your computer. But I'm going to start by just question that. Something that's quite unusual is because there is such an ill-defined, in fact, practical completion is not defined in the JCT. It's the term is used, but they'll define it. But we will regularly see that clients will actually draft the wording of practical completion. Do you think that's helpful, Seth?
No, because I think the common law is defined with words. But we've looked at some very, very complicated commercial contracts. For instance, I quite like the subcontractor one where they give notice as how finished. And if it's not counted by the end, they have. I think it's quite good for a commercial contract. With a residential contract, contracts I do with people who want, let's say, savvy with contract information. I think we need to stick with the basic principles. You get practical completion, but it's totally finished. And we've got is this should I do them? We just look as the nonsense would they totally finished with no paperwork.
Questions from you. You should have asked at the beginning, just as a show of hands under the group here, how many people are architects? Majority, and right up, once I can see them. Building surveyors, any QSs, engineers. Who else have we got? Excellent. Oh, contractor. Very good. Yes, yes. Oh, right, yes, yeah, right, yeah. Contractor. No, just use it. Okay, now, you are not being filmed, so the people in the room are not being filmed. How many of you have issued a practical completion certificate with a list of items, patents that needed to be finished? Hands up again. No, I didn't see it. But we've all done it. Okay. Yeah, we've all received them. We've all seen them. And yet, what we're hearing is that actually is not allowed. And just emphasising something that Seth said earlier on. The word snagging doesn't appear anywhere in the JCT. Whilst it has been picked up and appears in the case law, the word snagging is not in any of the standard forms of contract. And yet we all have a state of art and understanding of what we think it is. And also, can I emphasize again, show of hands, and it's Chatham House rule, nobody's going to pick you up on that. How many of you have issued more than one snagging list? Well, I've seen multiple snagging lists on jobs.
Can I just say the first case I looked at, the judge referred to snagging list division A, B, C, and it went up to J. So I've lost count how many that is. So the judge went through each of the snagging list revisions. It was a house. It just,
So what did the architect and what did he or she was doing?
well, the judge thought the architect was doing the job. And the judge went into, and I mentioned this, and you can read the case, if you're going on holiday, what's the book to take? This case is 154 pages. And the judge went into, as the architects will know, that these are kind of detailed questions. The judge went into the small scale detail of, is there mortar below the cavity tray and above the cavity tray? Or is the cavity tray just on the masonry, which of course is wrong? These were the level of details Mrs. Justice Jefford went into. It was just remarkable, the amount of detail. But heaven knows. Sorry?
Under the cavity.
Let's not get into technicalities, because otherwise it'll be.
You can't see it. No, you can't see it. I mean, these are the sort of things. I mean, the specification may ask them to leave the DPC to 2 or 3 millimeters. So check it all this. Building control needs to certain height, and also like that.
Oh, yes, but you're only seeing the
Tiny
side, yes, on the
yes,
superficial, you
that's
don't know
it.
what's behind it.
but if you don't see the mortar below and above, then it's not been installed and built. And if it was a DPC, the whole building potentially was. No, but this is the level of detail that I got judged by. I thought it was quite outstanding. And revision J of the snagging. No, I've never done that. Never done that.
So this is nearest Sheffield. Yep.
Mrs. Justice.
Yes.
Sorry, I don't know.
Eddie, we've been told that the chat box isn't available. People put some questions into the Q&A. You got chat box?
Yeah, I've got Q&As, yeah. Yeah.
Okay. So
I've got,
in the Q&A.
yeah, sure. So I've got a question from Kerry Barr. Can a client object to the architect issuing a PC?
Yes. I'd be delighted. I normally have clients saying, you know that bit of work I've finished? I'm sick of it. I just want to move in, get on. I don't care if they haven't finished. But this is the other way around.
Mm-hmm.
The client saying, I don't want you to issue PC because of it. I would have thought we need to listen to the client. I mean, the contract administrator needs to make their own mind. But I would be inclined to say the client's paying. And if they're saying don't issue PC because this isn't finished, I think she'll listen to it. But I always get the other way around. I'm sick of the building.
Yeah.
I don't care about the portable holder that's kind of missing. You just get rid of them.
Yeah. Okay. I think that there is case law, which is basically the case, but it was a developer in the market of and so he was trying to avoid taking possession, and the judge said, "I'm not having this. You're getting stupid." In other words, just because he couldn't reach off the floor, he was, to all intents and purposes, it was practically complete. Any sensible certifying architect would say it's complete.
Yes.
And so the judge, the judge,
Didn't want to pay the whole.
That's just the dead chair.
given the way that market has gone over the last 2 years,
With a change of the.
yes, normally the clients desperately want to take possession. Exactly as you say, Steve, over the last 5-10 years, your happy indications from contractors, so developers, will be paying it out. Because they don't want to pay extra attentions, they don't want to bring it to the market yet. And then they also think if I delay it, I'm going to hit them for LODs. So I wouldn't have any interest in. So I interrupted the video back.
But so I've got another question which I think that we've dealt with, but I'll read it anyway. Just to is it possible to issue PC cert with a note stating that PC is subject to items on the accompanying snagging list being completed?
Well, this was really the question that was asked earlier. Well, it's not really.
No,
I was trying to put it differently.
yeah, we won't talk about that. So we
After an hour.
I know, yeah.
Okay, I think the message has to be made, and it has to be made bold. You do not issue practical completion with a list of patents, defects in the case law, and we've gone through various ones, but we go back to Wilson Dickinson, we go back to Liability. Yes, all of these. If you are going to do that, well, we've got to be de minimis. That's the word that comes through very strongly. they've got to be absolute diligence. Otherwise, you're liable if you issue practices.
And as I said in the notes,
Fine.
ask yourself,
Yeah.
would I be happy to pay under my own pocket
Exactly.
if the builder goes belly shape
Mm.
and I have to pay to get somebody to come in to do it?
Yes.
And the answer is normally going to be no.
So I'm just looking at it, some of them, if it's been done already. And for whatever reason that was to. Arbitration. That mean that PC certificate has been issued, it's not valid.
Now, I don't fully get your question, but
If it's been issued, the PC was issued with the patent defect list.
yes,
Let's say I'm on the law, yeah.
yes,
And then
yes,
become split.
yes.
Does that mean that it's gonna be like, it's not a valid certificate?
Well, I went through a number of cases. Now, just if I can explain, if the dispute is referred to arbitration, the arbitrator can open up the certificate, look at it in detail. But if it goes to the court, as you say, will say valid or invalid. That's all they can do. So it's very likely, if the court looks at it and says, well, these are the agreements, they will say it's just invalid.
That's what's next to that, which is the important message to go across to the people in the room today, is that what you've just done is open yourself up to then potentially getting sued by your client. Because you put them in a position where they may now be claiming that after your actions, they could have avoided some loss that they now go to incur. Question over here.
What's the difference between latent defects and snagging? How do I define them to a client? Some people want to determine exactly.
Well, they are the same, yeah.
That's that,
Yeah.
yeah, because some clients think that, paint job problems are stopping them to issue a PC, and how do you tell, is that enough to stop
Yes.
PC paint jobs?
It's got to be outstanding works.
Outstanding, or it is defective. So it's not been applied because of an effective recommendation.
The works not in accordance with the contract's terms.
So for instance, if it was work on fresh wood, and they hadn't put the aluminium primer on to stop the knot screening through, and you found out, you could say you need to go back and you need to put the aluminium primer on, and then put finishing coats on, because all the knots are going to start coming through within a year. So in that case, it's defective. Now, it's difficult if you've got a client. I've had clients who are kind of jobbing interior designers, and they kind of put their very high magnifying spectacles on. They look this far away, and they say, "No PC." That dot there, and I say to the client, "Well, you really need to stand a meter, look at it as opposed to."
This is exactly.
And then they start screaming at me and not the building. But it's difficult because you've got to draw a balance between the two. And maybe you've had clients like those.
That's exactly what I was.
So you have to work out whether you feel it's been finished to a reasonable standard, whether it's.
I had a client that denied the sample for 2 weeks, and they put the 2 weeks, they sent it off for 100%. And nothing went forward when it was hard to deal with that client.
And if it's inevitable,
Yeah, then
it's going to be black and white, and then there's an awful lot of grey in the middle.
oh yeah,
And then there's-
unless I told you so.
See, that's difficult for us in building, because people.
Yeah, I mean, you raised the question, I think, that exactly who is responsible for doing this, because I, in my ignorance, always thought it's really primarily the contractor's job to not even have any snags in the area as well.
Yes.
And that's the way this is going back a while, and you're saying it's the CA or architect. But I do building surveys as anyone, and I've said to my secretary, I really do not want to go onto a new build site, honestly, because I think that potential client end user who is going to be buying that property, I'm doing a pre-contract survey, will be expecting me to do a snagging list. And I know, because I watch programs and you've probably seen them, there are, and maybe child surveyors, I don't know, of the building industry, who go around doing snagging, and that's their job. They're acting for the end user, I think. I haven't seen the contract. That's a very interesting scenario.
When you pick up on just this thing about. Because again, many of you will have responsibilities for refusing to snag until the builder is, in other words, until he is in a position to say to you, honestly, I do believe that this is practically complete. I have been who turned around, who started with on 2 rooms and then moved offside. Yeah, so no, this is not anywhere near that full completion. You know, it can be like in a week's time.
But you could say, if they say, I
Yes.
think I'm finished. You could kind of do 2 rooms and say, look, I've already got 20 given, so I've got 2 rooms.
Don't we?
I mean, it's, yeah, you have a look at the minutes and check the work. Well, we've got more questions.
No, I've got one more question, from Martin King.
Yes.
The question is, does Seth have a view about the situation, including the question of whether the certificate is valid, if the CA verbally confirms that the PC has occurred, but then delays issuing the certificate of PC by a number of weeks, circa 10 to 12, and states PC has occurred on the date when the certificate of PC is issued?
Well, this is what I was going through, picking up with a very minute detail on the certificate. That if you say it's been achieved on the date, and then 10 weeks later you issue it, you've got to go back to the date that you said it was achieved, because, as I say, liquidated damages accumulated.
Yeah.
So in fact, what's their money?
Yeah.
Unless you find more things that make you change your mind. So it was difficult to 10 to 12 weeks. It's an awful long time. I was thinking more of days as opposed to 3 months.
Got another question for
Not
you.
good.
But you haven't answered my question. No, you haven't answered my question.
You will do, but I think you're not talking about you're talking about certificates, aren't you? You're talking about
mortgage. Yes, I'm talking about the real world, the end user.
consulting certificates for the sale of premises that will be done by the government. So you get a
Do you
survey.
expect that to be the same as a practical?
No, it isn't. No, it isn't.
Well, if I.
Right.
Yes. Very serious. And as an architect,
You haven't got a market.
an architect has been struck off recently for doing this, just measuring acoustics.
So,
Yes, what's the next one?
the standard PC cert includes no reference to building control. Should BC final cert be provided before PC? It's PC to that.
Can you just say that slowly?
Yeah,
till I get-
so it's from J. Lingard, and it's the standard PC certificate includes no reference to building control. Should building control final certificate be provided before PC?
Okay, so let me answer that. There are quite a lot of things you need to get in place before you issue PC, and that's sort of paper.
Yeah.
And the local authority I manage is Merton. They require an electrical testing certificate. They are required to visit and run through everything. And they have to inform you that they're happy. Because they're only looking at building control matters. So the building control matters must be agreed by the building control officer before you can give the whole project your completion certificate. So I say yes, building control must have visited. So when it's reaching practical completion, you need to organise building control to come in to do the inspection and to certify that they need to have all the testing certificates they require. And the minimum is electrical testing certificate. And sometimes they may say, I would like to have some calculations for that voltage connection, something else, and at the end of the thing. So that's all got to be done before. So that's a very good question. Totally agree.
I've got another good one here, I think. Does the Building Safety Act liability periods of 15 and 30 years supersede the 6 and 12 year limitation periods?
Okay, now that's another Now I've listened to lectures by QCs, KCs on that.
We'll cover this
And,
anyway.
and the Building Safety Act, I think, is another.
We had the talk in April, but it said from was, and we had hundreds of people on we hundreds of people back on its presentation was just the most thorough with anybody listening to. When you not registered would like to see the video, email me. We'll make the video available to people who didn't register at the time. But it was a thoroughly practical and researched event? And I think the answer is yes. I think that's the whole point. Is that it will be extra to the only limitation periods. Otherwise, we must be well.
Yes.
Can I just say one thing I will say, because obviously I'm interested in this dealing with disputes. The building safety is retrospective.
Yes.
Laws, when they come out, they apply to what happens in the future. But there are two acts, the War Crimes Act, apply to war crimes and the Building Safety Act does the same. It's work that you did 10 years ago. Is it 10 years or 12 years? You can go back. It comes under the Building Safety Act, and then it goes forward to 30 or 40 years. It is so complicated, which is why it's got to be dealt with by one talk on its own. But having said that, until there is case law, I really don't know how the judges interpret it. And it's really to do with high-rise blocks of flats, and people being able to get the planning change, they can go back and get the designers, the builders, and the people. So that's called the golden rule. So if you're looking at an act of parliament, you've got to ask yourself, what was the purpose it was brought out for?
Yes.
So you've got to interpret it based on that. What's the golden rule? Is it's to get the developers who have all this flammable cladding in the buildings, who are claiming that it's past limitation, to pay for the removal. And that's why it's retrospective and goes forward as well. So that's got, so it's not exactly the same as the previous. And it does deal with generally high-rise buildings.
Yeah. What is your view? This is for anonymous. Sorry. What is your view on whether PC can be certified where guarantees are outstanding for works? Example, for M&E items or guarantees for roof recovery works.
And this is, I'd be inclined to wait. Because normally the guarantee comes through the contractor. And you don't have the guarantee because the main contractor hasn't paid the sub. I'm just thinking of the roof.
Yeah.
I normally, if it's a flat roof, I do a Bowden. If you get a 50-year guarantee, if it's the Bowden contractor. But if the main contractor hasn't paid the Bowden contractor, you don't get the guarantee. So if you haven't got the guarantee, I'd be worried.
Yeah.
Because he hasn't been paid. He's going to want to be paid on the completion certificate. For subcontractors, he hasn't paid, and we don't have the guarantee. So I've been inclined, you've got to really wait to find out what's going on. That's another very, very good question. I'm just thinking.
This is where I would be, if I would do amendments to the contract, one of the things I would write in, so practical completion will not be issued until. So if you told them, you'll be reminding them through the whole contract. So that therefore,
But the contract will say they have to provide the guarantee.
Mm.
And the question is it before or after PC? But the problem is, if you don't get it before, you may not get it at all.
Yeah.
Not just say, I took some slides out because I was going way over. I took one slide out, and I got a phone call one day. I was working with this lady around me, said I'm a solicitor, and I had some architects to work with him. So what is it? And she said, they are very famous architects, and I can't get an expert architect to give them a fifth. It's no scared because it's such a well-known architect. And they said they got their young jobbing architect on a project, and he wrote a practical completion certificate. And they've had all these problems. And she said the jobbing architect said to the builder, look, there's all these things, plus a million others. And the jobbing architect said, well, the builders agree he's going to come back after the PC certificate. So, of course, he does the PC certificate, and the client contacts the builder and says, well, you're going to come back and fix this, fix that, fix this. And the builder deliberately goes into liquidation. So now I'm called to survey the house, all the problems, and the case potentially is before the money already done. They want to litigate. And obviously she's going after the architect because they allow these things to exist when writing the certificate has been paid to 97.5%. The guy's furious. And that was an example I had as I took it out. So I was able to Any more questions?
But there's actually quite a lot, so how long have we got?
Can you pick one or two good ones?
They haven't been very good so far.
No, they've all been good, but we don't want to say answer the same thing.
Yeah, indeed.
Yeah, I do.
So-
If I was
Yeah,
making.
we can insult the comments. So-
No, they were
Okay.
very good questions.
So here's one, it's from Anonymous. As you said, there is no requirement for snagging this within the contract. Why would you do this when you open yourself up to contractors being particularly difficult and pushing their liability onto you as CA if not everything is completed?
Well, this is the view of Dr. David Chapman, and I went through the case of this couple of months. And the judge went through revision A, B, and the judge is saying the architect is clearly doing his work. I also went through the Court of Appeal case where they considered the snagging list, and the judge said, you know, Mr. Conway, you've done this list of all the things that bug you on the project. Are you expecting the builder to go in and spot all these things? Why have you got the list and you don't give it to the builder? You can't recover damages because of the work, you know, you haven't told them is defective. And you're coming to the court and saying you want damages for it, and you didn't give the list to go. So it's obvious that snagging this, in my view, should be done. But of course, the Mr. or Mrs. Anonymous is quite right that potentially, as Dr. Chapel says, you are leaving yourself open, claims from the builder. And Dr. Chapel's view is that if once they finish the snagging list, you come up with something you didn't spot earlier, then obviously they're going to snag it. And that's why you need to say on the snagging list there may be other items in the future. So I'm sorry, I don't agree with that.
Okay,
Eddie, can we make this the last one? Because
okay,
wrap this up.
yeah, final one then. Could you elaborate on the 6 to 12-year period in contractor liability under tort? There was also a 15-year mentioned in there.
Yes, well, it's very simple. It's a contract underhand at 6 years. It's a contract executed as a deal as 12. Goes from accrual. The Latent Damage Act has got a long stop of 15, but if you spot it on year 10, you've only got 3 years to bring the claim.
Well,
So if you spot it on year 12, you've still got 3 years, which is the 15-year long stop. So under the tall Latent Damage, so this goes back to Pirelli, which was a very tall smoke town, and they didn't spot the damage until that was the golden rule. You know, when you can't see what the damage is. So if you don't discover the damage until year 12, when the standard contract expires, under the Latent Damage Act, you've got another 3 years, but of course that's tweaked. So the rules generally are important, you can't cover more than the rules cover under contract, but of course the period is extended to allow for where you can't actually see the link. It's all hidden away to
So it's a contractual liability when the one from the completion.
yes, that's
If it's cautious, it's
yes.
going to be when it was discoverable. So that's why.
That's when the 3 years applies, but I think the 15 years would probably still accrual from PC. But of course, you've got to raise the claim when, and it's not when it's discovered, when it's reasonably discoverable. Because people can stay on you. Discover it. We suppose the board will say, yeah, we could.
It's a matter of public policy that they might do it.
Yes, the lockout.
And then we got the public safety, which is just blown hole in everything.
But of course, that is specifically dealing with lots of flats.
sure.
That's the goal.
Yeah, I understand it.
That's what it's trying to address, as opposed to projects that we do. Good.
Well, that's wonderful. The website, because I'm interested in as well. And I think the people in the room, people online for attention to journalists today. We wanted this to be reasonably practical, reasonably swift, not too confusing, but wanted to get practical things for you, because we were going to face these on a daily basis. And I didn't say it's not, but what we wanted to pick up on is the things that message an arbitrator and an adjudicator. Seth sits as an adjudicator as well. Qualified arbitrator as well?
No, I trained as an arbitrator, but this stuff with education.
And we get to see the horror stories. We get to see what's actually going on there in the real time. I mean, we work in the building industry for 8 years, and you see all these things which technically people are doing. There's a lovely case in the architects, but the judge said of the architects that they were doing their incompetent best. It's a fantastic quote. It's an old place now, but anyway, I mean, there was no malintent from him. He was just doing what he thought he should, but it was just completely deranged. And I'm not getting into details. It's anybody who does contract administration. But we wanted to take it back to basics. So in 2 weeks' time, we're going to be looking at extensions of time and delays. Because again, it's an area which people really do get on their ears a bit. And that would be Seth taking the lead. And then if it's time, I'm going to be looking at the thing that you most often get sued over. And that's because it's all about money. And unfortunately, I don't know what, get people worried, but the things that the thing that leads to money is certificates being wrong. Pay us notices being wrong, because that of course means your client may end up with a liability to pay. So therefore, that's going to be 4 weeks' time. So can I ask you please to, well, firstly say thank you for attending. Thank you for attending online. And can the people in the room please show your appreciation of Seth? We look forward to seeing you in a couple of weeks' time. And 1 or 2 of us will be thank you. Thank you.
Do we know the venue?
Yeah, we would have found it.